having any business before this honourable court now draw nigh. Give your attendance and you will be heard. God save the King.
I begin by acknowledging the Gadigal of the Eora Nation, the traditional custodians of the land on which this building sits, and pay my respects to their elders past, present and emerging. This special sitting has been convened to farewell Judge Levy, SC. I extend a very warm welcome to you all this morning. I particularly acknowledge the presence of the members of Judge Levy's family, his wife Eva, daughters Monica and Dr. Philippa, their husbands Nathan Wise and Dr. Brett Laurie, and granddaughter Sophie, who has been permitted to wag school, I'm told. Sophie is representing the other 5 grandchildren, all of whom are attending a school music camp. I'm also privileged to welcome the Chief Justice of New South Wales, Andrew Bell, President of the Court of Appeal, Julie Ward, Justices of the Court of Appeal, the Supreme Court of New South Wales, the Federal Court of Australia, and other judicial officers. It is of particular significance that Acting Justice Michael Elkheim and his wife Susanna are present. Justice Elkheim was sworn in as a judge of this court on the same day as Judge Levy. Judge Levy, you have served this court with distinction in the court's civil jurisdiction for some 15 years. You came to the court in 2008, however, that was not your first experience with the court, which is celebrating its 50th anniversary this year. You worked as an associate to His Honour Judge Humphrey Henchman QC between 1971 and 1974. During that time, the modern district court commenced. The then Attorney General, the Honourable John Hatzisilgos, at your swearing-in ceremony in May 2008, referred to your talent as an associate of drawing caricatures of appearing counsel, which was said to be very apt likenesses. But I have also heard of experiences that you had as an associate indicting an accused in a criminal trial, which might partially explain your very strong preference to sitting exclusively in civil matters. After confidently reading a lengthy indictment at the commencement of a trial in which the accused was to be placed in the charge of the jury, you mistakenly named the Crown prosecutor who had signed the indictment instead of the accused. The Crown prosecutor meekly entered pleas of not guilty to all the charges. Unfortunately, at that time, you were a particularly slow learner, as you indicted the same prosecutor on another occasion. I briefly mentioned you admitted to the bar in 1977 and were appointed senior counsel in 1996. Your exemplary career as a barrister was marked by your work in personal injury, medical and professional negligence. Upon your appointment as a judge, you quickly embraced all of the work of the court's civil jurisdiction. Your prodigious appetite for work has resulted in some 1,368 substantive judgments. Now, this is of particular importance. The word count of your published judgments on case law, I'm informed, amounts to some 5,344,000 words. You are known for your careful and comprehensive consideration of all issues that have been raised. As a judge presiding in civil cases, it was inevitable that you would develop a respectful relationship with the Court of Appeal. At times, you expressed to me your disappointment about some observations made in appellate judgments. Surprisingly, you did not approach me when your judgments were upheld, which was not infrequent. For instance, appeals against your judgments in 2 complex medical negligence cases, Dean and Pope, 2022, New South Wales CA 260, and Dupar and Lee, 2022, New South Wales CA 15, were dismissed last year. When I became Chief Judge, I was unaware that you were a self-taught silversmith. During the first year of the COVID-19 pandemic, I was looking for ways to expand the size of jury rooms to ensure compliance with the 4 square metre rule. The belief was that beside your chambers on level 18, there was a library and photocopy room. The Sheriff of New South Wales was most alarmed to find that that room you were manufacturing jewellery. The object that you were turning into intricate and delightful pieces was a well-known COVID symbol. Unfortunately, the room was requisitioned and your manufacturing continued offshore. Every Christmas, you have very generously given me a fine bottle of red wine. Curiously, on the bottle's label is a picture of a black sheep with the words underneath, "Every family has one." I've been very uncertain whether that was a symbolic reference to me or to you, but I do not expect you to resolve that mystery for me. Your contribution to the court has not been confined to the production of civil judgments. You have been a member for some years of the Law Society's Alternative Dispute Resolution Committee. Your warm personality, coupled with a sense of humour and willingness to listen, made you a mentor for many judges. You are a consummate gentleman. These characteristics, together with your commitment to the work of the court and dedication to justice, endeared you to all of us who have served with you. May I also express my thanks to Dulce Lalo, your associate. Dulce was your personal assistant whilst you were at the bar. You have made a formidable team. Judge Levy, I'm aware that you're not ready to leave your judicial career behind and dedicate yourself to your undoubted ability as a silversmith. I am pleased that the Attorney General has appointed you to be an acting judge. Accordingly, on behalf of all your judicial colleagues, I wish you and Eva a very happy semi-retirement. Mr. Toomey.
Please the court. As is customary on such occasions, I too acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. It is both a pleasure and a privilege to represent the New South Wales Bar in acknowledging Your Honour's services to this court on the occasion of your retirement as a permanent sitting judge. As we've just heard, Your Honour will continue to serve in the capacity of an acting judge, and with that in mind, this is not a final farewell. Indeed, upon hearing the news of Your Honour's intention to continue in that capacity, the Plaintiff Lawyers Association have deferred their plans for a 14-day period of mourning. I'm also informed that the insurance futures market took a sharp dive after earlier rallying on the news of Your Honour's impending retirement. Today is an opportunity to thank Your Honour for your work at the bar over 31 years and for your considerable contribution to the administration of justice in this state since being sworn in as a judge of this court 15 years ago. Your Honour, as we have heard, has sat principally in the civil jurisdiction in that time, which, as we know, hears a broad range of cases, including those involving personal injury, professional negligence, defamation, commercial disputation, matters of administrative law, and childcare appeals, which you have managed with great expertise and indeed, as I'm about to outline, with some personal insight in the last of those areas. Your Honour had your own early experience of out-of-home care at a time when your parents were too ill to assume full parental responsibility. They had found refuge in Australia as Holocaust survivors, having experienced the horrors of concentration camps, and they were understandably not well. That saw Your Honour temporarily cared for by others. Your gratitude for the help that you received as a child has informed a lifelong belief in the importance of philanthropy and charity, encouraging others to do so and leading by example through your own charitable works. There is a continuing legacy of this philanthropic approach at the bar to be seen in the practice of the newly announced silks, choosing a single charity to which each donates a sum of money. That was initiated by Your Honour on the occasion of your taking silk, in place of the previous tradition of gifting an objet d'art to the bar. and remains the practice to this day. Your Honour was also instrumental in the establishment of Bar Care, the independent professional counselling service which helps members of the bar with mental health issues, free of charge. The true extent of the beneficial effects of those two initiatives will never be truly known, but it is undoubtedly significant. Your legacy as a judge, as we have heard, is faithfully recorded in the publication of an impressive 371 judgments. I'm assuming that figure is those which have been placed on the internet and not the number that the Chief Judge quoted. But nevertheless, that is evidence of Your Honour's hard work and dedication. Your Honour's judgments, as the Chief Judge observed, are well known to be comprehensive. One of the more comprehensive, at 335 pages and 1,078 paragraphs, was Your Honour's decision in Lee and Dupar. That was a medical negligence claim concerning the outcome of a failed surgical procedure. Helpfully, Your Honour included a detailed table of contents to assist the reader with referencing the factual background, issues and evidence, medical records and documents, expert opinions, assessments of the reliability of the evidence, the findings and the ultimate disposition. The judgment also included an appendix with a glossary of medical terms. Across other judgments too, Your Honour would provide references, as Your Honour put it, for the benefit of the time-poor reader to assist in locating passages and findings on specific topics. These are examples of Your Honour's meticulous attention to detail that is characteristic of your approach in all that you do. As an advocate, that characteristic manifested itself in your frequently creating detailed charts and visual aids to take to court. In your personal time, as we've heard, it has expressed itself through your pursuit as an amateur silversmith, making beautiful pieces of intricate jewellery as gifts for loved ones. As a judge, this trait has been evident in the detail and structure of your written decisions. Your Honour's judgments were invariably executed carefully and with the necessary detail for the evident dual purpose of serving to clearly inform the losing party of why you had ruled against them and, of course, to provide the necessary reasoning on identified factual and legal issues for any judge who may have cause to review the matter on appeal. Whenever there were appeals from Your Honour's decisions, however, it was rare that the grounds should include failure to provide adequate reasons, and rarer still that such a ground should succeed. In the matter of Lee, already mentioned, and in many other cases, this court had the benefit of Your Honour's background at the bar, specialising in medical negligence, including many cases of catastrophic injury caused at birth. At the bar, Your Honour carved out a reputation as a leader in that field, driven perhaps by what had been a long-term interest in medicine itself, an interest, I am informed, which might have seen Your Honour pursue a career in dentistry had it not been for the wise encouragement of your wife Eva towards law. Your Honour's medical interest found expression in your legal career, which for a time took Your Honour overseas to practice at the English bar. In the UK, your knowledge and experience in the medical field were acknowledged by your acceptance into the Fellowship of the Royal Society of Medicine. It is thought, possibly, as the only Australian lawyer ever to achieve that accolade. Your Honour, I am informed, continues to retain a medical library at home. In Australia, one of your best-known cases as senior counsel was that of Simpson and Diamond, 2001, New South Wales Supreme Court, 1048, in which you appeared with then junior counsel, now Supreme Court Justice Julia Lonergan for the plaintiff, in a medical negligence claim involving cerebral palsy, achieving a then record award of damages of $14.2 million, later reduced to some $11 million on appeal. That award is said to have been a factor in the so-called insurance crisis, which was met with the introduction of the Civil Liability Act. I'm not sure, it must be said, that that is something which attracts the gratitude of the common law bar, but certainly the respect. As a courtroom advocate, Your Honour's opponents found you to be unnervingly well prepared and thorough. Medical experts were subjected to penetrating cross-examination, always informed by your considerable breadth and depth of knowledge of the subject matter. As I briefly mentioned earlier, Your Honour's courtroom preparation sometimes included the production of detailed visual aids for presenting technical knowledge in precise, colour-coordinated flowcharts. The only time this is known to have been of little assistance was when the presiding judge informed Your Honour that the careful colour coordination had been ineffective on account of his colour blindness. In the days before digital technology in courts, Your Honour's presentations would be printed out in the size of a picnic rug and brought along for presentation to the court. This was possible because of Your Honour's enthusiasm as an early adopter of various computer models and technically advanced printers in your chambers, always looking to upgrade to the latest model in pursuit of the perfect presentation of the case. We must also acknowledge in that regard the great support of your then PA, now associate, Dulce Lello, who was trained in the use of all the new technology in support of your busy practice. When Your Honour was appointed a judge, Ms Lello followed you to become your associate. At that point, you had already been working together for an impressive 26 years. Now, as you retire as a permanent judge, Your Honour's working relationship with Dulce is coming up to 42 years and looks like continuing in some capacity for your future acting judge duties. This may well be a record for long service for a judge-associate relationship. In chambers at the court, Your Honour formed good collegial friendships with fellow judges, particularly Justice Michael Elkheim, who left the court to take up his role as a Justice of the Supreme Court of the ACT and now as an acting Justice of the Supreme Court of New South Wales, and with whom, as we have heard, you had shared a swearing-in ceremony in this court, and with His Honour Judge Peter Johnston, now the Chief Magistrate, who I'm pleased to see is sitting today. I also acknowledge the presence of Justice Elkheim today. There were many morning teas shared with their honours in the common area on level 18 of this building. After Justice Elkheim's departure, Your Honour is reported to have printed out a photo of his face to stick to a chair at the morning tea table. I can only imagine it depicted His Honour's mischievous smile. As a judge, Your Honour has been meticulously courteous and, by and large, provided a pleasant courtroom experience for those appearing before you. I say by and large because, of course, litigation by its very nature produces winners and losers. And returning to an earlier theme, the losers in Your Honour's court might not always have chosen the adjective pleasant for their particular day out. Nevertheless, always mindful that there is a limit to how much humour can, or indeed should, be brought into the courtroom in the conduct of serious proceedings, Your Honour usually managed to commence hearings with a view to good-humoured cooperation and to weave in the occasional bit of wordplay at the outset to set the scene for the hearing. During your time at the bar, Your Honour had always appreciated it when a judge would make a comment from the bench that on later reflection would prove to have been a sophisticated, if subtle, reference to what was to transpire in the case. In my experience, Your Honour sought to emulate that. From the perspective of the bar, Your Honour was always composed and respectful in exchanges with counsel. You were quick to identify the key issues in a case and ensure that each party had a proper opportunity to present the best evidence available in support of their cause, while still observing the requirements of the Civil Procedure Act to ensure that the proceedings be just, quick and cheap. As Justice Harrison once amusingly observed, however, it is important to note the comma in that phrase, and Your Honour always did. In the conduct of proceedings, Your Honour demonstrated a prodigious knowledge of case law and principles amassed in your long years at the bar and then on the bench. It has also been said that a most admirable quality of Your Honour is the respect that you show to all persons attending before you, regardless of their professional or social standing. And although appropriately dispassionate on the bench, Your Honour has naturally cared about the significance of your decisions. It has been heartening for Your Honour, in that vein, to receive letters from litigants several years after the resolution of a case, informing Your Honour of happy developments since. In one example, a mother sent Your Honour a note of thanks 5 years after your decision in a childcare appeal had returned their daughter to their care. The mother said that not a day goes by when they are not grateful for that decision. In childcare appeals, Your Honour made a point of making decisions quickly in acknowledgement of the urgency that by their nature ordinarily attends such matters. In March of this year, Your Honour heard a childcare appeal in the matter of J&T in the Department of Communities and Justice, resulting in a decision to uphold the appeal by the biological parents seeking the restoration of 2 children to their care. There had been 7 sitting days and over 5,000 pages of evidence. In preparing the judgment, there was also a need to consider evidence related to the Aboriginality and cultural identity of the children, the subject of the care proceedings. With that considerable task, Your Honour still managed to deliver your judgment, together with detailed reasons, after only 7 days. There are numerous other examples of similar feats, seeing Your Honour delivering timely and thorough judgments over the past 3 years of Your Honour's extended judicial service after opting for the raised retirement age of 75. Working hard right up until the end, with your last judgment published just days ago. It should be observed that hard work is something which Your Honour has with which Your Honour has a lifetime familiarity. Working continuously since the age of 12. Many of the jobs you have performed came with occupational hazards. And if Your Honour were a cat, I'm told you might have exhausted the traditionally allocated number of lives before a career in law had even crossed your mind. It is said, apparently without the usual hyperbole deployed in such accounts, that you survived a 33,000 volt electric shock, were almost buried alive while digging a trench, and were exposed to noxious gases while shoveling sewerage and sand in a not well ventilated sewerage tunnel. The last of those events brings to mind the scene in that great Australian classic film, Kenny, when the eponymous protagonist tells his irritating co-worker from his position in the tank which he's cleaning that there's a smell in here that will outlast religion. During recreation too, Your Honour has had your fair share of close calls, surviving numerous spills from your bicycle on highways, a near miss with a ricocheting bullet, and actually being shot in the arm with an archer's arrow. Who would have thought, Your Honour, that the insurers of New South Wales would go to such dastardly lengths? Perhaps, however, it is the relative safety of a courtroom that your wife Eva was encouraging you towards in suggesting that you might be suited to a life in the law. Your Honour, with Eva, to whom you have been married for 54 years, you have 3 grown daughters, Vanessa, Monica and Philippa, and 6 grandchildren, Sebastian, Rafaela, Emily, Camilla, Olivia and Sophie, who affectionately call you Pops. Today we join with Your Honour's family in celebrating your contribution to the profession and to the work of this court, characterised by your courtesy, generosity and dedication to the task. on behalf of the Bar, congratulations on another milestone in Your Honour's life in the law, and we wish you the very best in what is still to come. May it please the Court.
Thank you, Mr. Turner. Ms. Paul.
May it please the Court. I too acknowledge the Gadigal of the Eora Nation, the traditional owners of the land on which this Court stands, and pay my respect to their elders past, present and emerging. I acknowledge and extend my respect to all Aboriginal people who are here with us today. I'd also like to acknowledge Your Honour's family who are here with us today. On behalf of the solicitors of this state, it is a privilege and a pleasure to congratulate Your Honour on your work and contribution as a judge of the District Court of New South Wales over the past 15 years. Today is an acknowledgement of the capability, empathy and justice your service has so clearly brought the bench. It is also an acknowledgement of the fact that you managed to get a full-scale working gym through the doors of John Madison Tower. The Chief Magistrate who formerly sat with you on level 18 on the bench, as we've heard, with whom you often shared morning tea, noted that you had two very accommodating Chief Judges. They allowed you to self-fund the first gym in John Madison Tower by the bench, for the bench, with a commendable joining fee, donating to a charity twice a year. His Honour described you as a terrific individual who was very collegiate and supportive of his colleagues. The Chief Magistrate also mentioned Your Honour as unique for your amateur silversmithery, for knowing more about many esoteric areas of medicine than is common in medicine itself, and for your extraordinarily organised chambers. On this point, your daughter Philippa mentioned Your Honour's study at home, where there is a shelf of animal figurines for the grandchildren, organised by genus, which can be played with but must be kept in order. You're also noted by several colleagues, I'm not naming names, for the length and detail of your judgments. As has been mentioned, you were lucky to be backed in these by your associate, Dulce Lelo, who has been with you since you were at the bar. A nameless source, let's call him Chief Magistrate, said there were a very good working relationship between you two, necessary for accepting multiple edits of multiple drafts of judgment after extensive judgment. Whilst on the bench, you've seen a large variety of civil cases covering many areas of law. One notable one involved the notoriously hard to make out argument of seafood-related defamation, when a Coles manager loudly alleged in front of staff and shoppers that the plaintiff had been eating raw prawns without paying for them. The plaintiff was awarded $50,000. Back in your school years, your future career was not immediately evident, as you were not terribly interested in schoolwork. You described your rise to the bench as a miracle and your matriculation as a fluke, due merely to the fact that someone stole your bicycle in your final year of high school. All you were interested in then was becoming a champion cyclist. But with the theft of your bike, you set course to get out of high school using hard work and study. One way you did this was with self-approved leave from school on Wednesday afternoons, catching the train into the State Library to study. The inevitable caning in front of the school assembly for wagging failed to deter you from your personal odyssey. You initially studied dentistry, not an issue unto itself per se, but the problem came to the fore on the cusp of the clinical years, when you had the realisation that looking down people's cake holes for the rest of your life was not for you. Your Honour's words, not mine. So you abandoned dentistry and enrolled in the Barristers Admissions Board course and studied part-time at night. You then spent 3.5 good years in the District Court working as an associate to His Honour, the late Humphrey Henchman QC, and Your Honour couldn't have wished for a better mentor. When Judge Henchman retired in 1974, you took a job with the Government Insurance Office. Now, as the representative of the Law Society of New South Wales and the solicitors of this state, I am dismayed to recount this part of your career. You were never admitted as a solicitor. However, you did recently say, and I quote, "I've always worked collegiately with solicitors and it's always been a privilege to take their briefs and undertake cases for their clients. We've always worked as a cooperative team, and it's a great system. So, should Your Honour wish to get a practicing certificate with the Law Society, after all this is done, I can point you to our online forms. In 1977, you came to the bar, you focused on common law matters and personal injury litigation. In 1996, you became senior counsel. Some senatorial cases led you to professional development internationally, and lawyers and medical experts you met encouraged you to go to the bar in England. In 2006, you admitted to the bar of England and Wales, and in 2008 appointed to this court. Your specialty throughout your time at the bar is well known, medical negligence litigation. You never lost interest in reading science and medicine, and this was an area in which you excelled. But we need to go back because you were nicknamed Rambo in the 1990s. I am not making this up. After work, late one evening, you fought off two would-be assailants in a car park. They came off worse for wear. Although no doubt horrifying at the time, this earned you the action movie title amongst a select number at the bar. Of course, it must be mentioned that at the bar, Your Honour displayed a rare determination in representing severely injured people, securing exceptional outcomes for clients in areas of professional negligence. As has also been previously mentioned, you broke ground in the 2001 Simpson versus Diamond case concerning negligent use of forceps resulting in cerebral palsy, where Your Honour represented the plaintiff. There, you broke your own record and that of the Times, achieving a personal injury verdict of $14.2 million, subsequently reduced to $10.9 million on appeal. This case also established the use of international expert witnesses in these matters. And at the time, many thought it would erode parts of the insurance industry and pointed to the case to explain the introduction of the Civil Liability Act 2002. Justice Lonergan of the Supreme Court was your junior in this case and spent about 2 years working with you in the build-up to trial. During the extensive trial, Justice Lonergan remembers Your Honour fitting work around her need to look after her newborn daughter long before flexible working hours was the norm. More than that, Justice Lonergan saw that you did not push for high damages claims for notoriety or glory. You fought to support your clients. In cases too numerous to list, Your Honour advocated for life-changing compensation. James Renwick SC called you one of the best prepared barristers he has ever seen, really right at the top of the bar. He noted that your superb preparation meant you could deal with any opponent, and you have taken this marked ability and eye for detailed preparation with you onto the bench. Where Your Honour sits today is a great achievement for any member of the legal profession, but more so perhaps in Your Honour's case. As mentioned, your parents were survivors of the Holocaust, and when you were a toddler, Your Honour's family came to Australia as refugees. From there to a judge with an amazing, loving family. You have had what one former colleague describes as a remarkable history from a place where you didn't know anyone or have a leg up from anyone and made it to the top. Your daughter Philippa said that as she and her siblings grew up, you always made time for your children and family and made sure to be home for dinner. As a child psychiatrist, she also offered a professional assessment of your lifelong dedication to hard work, stating that you were mentally stable. Mr. Geoffrey Hilton, SC, another former colleague at law, put it simply, he is a mensch. He also spoke of your generosity, as many have, both with charities and when practising with clients with less means, noting that you were quite fine seeing those who couldn't afford to pay your fees, paying for those who couldn't. You have given outstanding service to the law, this state and this country, and you deserve a fine farewell. Except, of course, this is not a final farewell. Your daughter Philippa said that since you have been on the bench, the age of retirement has changed twice, and when you finally met it, you immediately accepted an acting role on the bench. Wherever that takes you, it is with the utmost pleasure that I stand here today on behalf of the Solicitors of New South Wales and say thank you, Your Honour, for your fine work with the law in all its forms. I congratulate you on this outstanding moment of recognition of your work in this court and service to the law. As the court pleases.
Thank you, Ms. Ball. Judge Levy.
I too join in the acknowledgement of the traditional owners of this land, noting their entitlements were never ceded. Thank you, Chief Judge, for your kind remarks and for facilitating this rite of passage to mark the change from judge to feather duster. It's a little overwhelming. I do not intend these remarks to compete in length with some of my doorstopper-sized judgments. A number of acknowledgements are necessary. I thank High Court Justice Gageler for his message as he was unable to be here today. Chief Justice of New South Wales, Justice Bell, President of the Court of Appeal, Justice Ward, judges of the Federal Court, Supreme Court, magistrates, former colleagues, commissioners, family, friends, members of the profession, too many to name personally. Thanks to you all for including yourselves and in this ceremony. And I thank those taking part online to take time from your busy schedules. Your presence here does me great honour. Thank you, Mr. Toomey and Ms. Ball, for your generous remarks, including the exaggerations. Your dragnet for information has covered a very wide field. I'm relieved, however, that you have exercised restraint in the face of some mischievous input from known miscreants. Today is my second retirement from the court. My first was an associate to Judge Humphrey Henchman 49 years ago on the 24th of June 1974. Could we have the slide, please? This photo, which I was hoping to have on the screen, there it is, was taken that day in Court 29A in the Mint Building in Macquarie Street. Thank you. I start by sharing with you a common experience, namely when strangers ask what one does for a crust. This can occur at times when we do not want to discuss legal questions or misconceptions or questions about cases in the news. I've found a strategy for dealing with such situations. When asked what I do for a living, I answer, I'm a writer, which involves a lot of listening, research and reading to find an angle from which to commence to write. If a follow-up question seeks to ascertain the genre of my writing, I simply answer human interest stories taken from real-life situations. If asked whether I've been published, I respond that I've published extensively. When asked how the critics have treated my writing, I respond that the reviews have been mixed because of the difficulty of satisfying all readers, but also noting that there has been some critical acclaim. I've been writing for 15 years since being sworn in together with my former brother-in-arms, now second cousin twice removed, Justice Michael Elkheim. I'm pleased that he and Susanna are here today. A significant part of my writing has concerned the Civil Liability Act. It has been said 23 years ago, one of my cases of notoriety at the bar caused a financial meltdown of the medical insurer, which then led to an indemnity crisis requiring a government bailout of that insurer. The ensuing clamour was a catalyst for the enactment of the Civil Liability Act. On this court, under a cloud of apparent penance for that debacle, I've recurrently encountered the need to consider and apply ad nauseum some of the complicated and difficult to interpret provisions of that Act. Paradoxically, a silver lining has emerged from under that cloud. It has had something of a mitigating effect on an otherwise lonely aspect of judicial life, namely judgment writing. In that regard, channeling the remarks of Justice Price at his own swearing in as Chief Judge of this court 9 years ago, He referred to the revelation that came to the late George Rummery QC in his time on the court. George announced that he had acquired new pen friends in the Court of Appeal. He described a process whereby they would publicly correspond with one another about their respective views concerning points to do with the particular outcomes of certain cases. Respectfully, I'm pleased to say that in my time that tradition has continued, and I too have received the benefit and enlightenment provided by similar correspondence. In that regard, I'm delighted to see some of my pen friends here today. A phenomenon I found interesting in the business of judging is that once a decision has been reached and delivered, one moves on and ceases to be invested in it. However, there remains hanging in the air just one tiny lingering tinge of a sense of non-fulfilment. For reasons outside my control, I've been denied the membership of an exclusive club which is known by the acronym CARC. The sticking point has been that the president of that club does not accept applications for associate membership based on High Court grants of special leave which were immediately followed by settlements that had the effect of restoring a first instance judgment previously overturned in the Court of Appeal. That said, I'd better leave this topic now, as two of my decisions still remain under review. Reprising what I said at my swearing in, I reiterate the everlasting gratitude that I have to this great country, where statistics show that we are mostly immigrants or the descendants of immigrants. Last week was known as Refugee Week, which was particularly poignant to me because 73 years ago, I was accepted and welcomed into this country as a stateless refugee immigrant. In the events that followed, I was most fortunate to have been looked after, educated, provided with opportunities for advancement, including to this privileged position. This has been in stark contrast to the historical experience of many First Nations people who unfortunately have had a much harder road to hoe. Disturbingly, that road remains marked by the obstacles of their poorer health outcomes, disproportionate overrepresentation in the juvenile justice system, including court-ordered out-of-home care, and in their overrepresentation in the prison system, especially on the north coast of New South Wales. Much equalising work still needs to be done. In contrast, and on a different note, channeling the sentiments of Albert Facey in his book of the same name, I've had a fortunate life to this point, culminating in the ultimate great honour and privilege of serving in the civil jurisdiction of this court for the last 15 years. For me, it has been a most remarkable ride. Continuing with Albert Facey's theme, how did I get here? It's been a confluence of fortunate events, the first of which occurred at the age of 2, when I was permitted entry into this country by those administering the now abolished Immigration Restriction Act 1901. I remain forever grateful for the exercise of that discretion where, post-World War II, any inbound ship was required to have a quota of no more than 10% stateless Jewish refugees on board. By those means, my parents and I were fortunately included. The first page of my laissez-passer refugee papers are prominently marked with a capital letter J in red, which shows that the ship's captain had included us in the counting of that 10%. Mention has been made of my encounters with jeopardy, risk and danger. In total, they indeed have exceeded the 9 cat lives. It is a wonder that I survived it into adulthood in light of those events. Some people might think that those events may have in part informed my approach to the assessment of common law and statutory notions of risk in personal injury cases. I can't possibly be the judge of that. You've heard mention of shoveling the proverbial Few tasks are more levelling than working down a manhole in the poorly lit and poorly ventilated confined space of a decommissioned underground sewer tunnel that has been pumped full of sand to shovel what was there into buckets to be hauled to the surface. The task was unforgettable. It seemed that the Water Board site engineers responsible for those works had especially reserved those tasks for university students working in their vacations. Nothing phases after that experience. It provided me with some of the graphic imagery for considering the expression "the muck of evidence," which Philippe Sands QC referred to in his book East-West Street when describing the forensic task of sifting evidence. Staying with the theme of good fortune, fortunately for me, as it turned out, my decision at age 15 was to reject the careers advice of my woodwork teacher. It was for the best. He suggested that I leave school with an intermediate certificate and take on apprenticeship and train as a carpenter. The context of that advice was somewhat disconcerting because he only had 3 remaining fingers sawn through right hand from an industrial accident. This was perhaps my first conscious exposure to the taught concept of foreseeability. Perhaps there was another subconscious reason that emerges, but using impermissible hindsight as an after-the-fact validation. In the context of my cultural background, no offence intended, it is well known that things didn't do all that well for a particular young Jewish carpenter. Scrolling forward to a point just 3 months before my leaving certificate exams, as you've heard, by quirk of fateful misfortune, my custom-built racing bike was stolen. Until then, as a member of the Enfield-Burwood District Amateur Cycling Club, I was training daily and in earnest as a competition cyclist. Like the back of my hands, I knew every bump and crack on the Hume Highway from Enfield to Liverpool and back, and the steepness of the Razorback. The loss of my bike was a devastating blow, as I was unable to afford a replacement. Therefore, study seemed the only rational choice that remained. On account of that theft, and in view of an encounter I had some years later with a couple of would-be assailants in a car park with malintent in mind, it was probably for the best that my work in this court has been undertaken only in the civil jurisdiction. I can now say to all those bike thieves and thuggish assailants upon whom I might otherwise have passed sentence, you don't know how lucky you are. I want to say something about the importance to me of mentors and mentoring. One does not reach this point without the positive influence of mentors, of which I've had many. Whilst at university, I had the good fortune of meeting the Attorney General for the Commonwealth, the Honourable Tom Hughes QC, whilst helping his handyman, my neighbour, to paint the Hughes house on weekends. I was planning and studying to be a dentist at the time. He not only made the astute observation that I was not a house painter, but over several weekends he took the time to explain something of how our legal system worked. His description of the role of the advocate made it sound very exciting. Around that time, I was most fortunate to meet the love of my life, Eva. We married in 1969 and last week celebrated our 54th wedding anniversary. It was Eva who convinced me that to take the leap from dentistry into law, thinking this would be a better fit career for my career, and it was. She was right, and as wives generally are. I was really chuffed when Tom Hughes gave me my certificate of fitness, fame and character, this being a prerequisite for enrolment as a student at law. However, making that change meant abandoning my non-transferable scholarship for dentistry and undertaking the Barristers Admission Board course at night and working as a builder's labourer by day for the first 18 months to make ends meet. The juggle was not entirely easy. It was in those events that it was fortunate that at the end of 1970, whilst Eva was attending night classes in library studies for her first career, a classmate working in the District Court Library told her there was a position available as a judge's associate in this court. I applied, I borrowed a suit for the interview, and despite some apparent rough edges, Judge Henchman gave me the job. I started in January 1971. That was a turning point for me. Since then, my journey in the law has been an endless source of fascination, stimulation, awe and satisfaction. Between 1971 and 1974, Humphrey Henchman proved to be the most generous mentor until his statutory retirement at age 70, when he was still very much on the top of his game. Before admission to the bar, what with attending to the demands of work, then being an employee of the GIO, which involved handling a large litigation caseload, the mix of study and family life was quite a juggle. In those times, there were a few moments of doubt and discouragement. Fortunately, Bruce Donald, the lead author of the first text on Australian trade practices law, mentored me through those moments. I welcome his presence here today. When I took the leap to the bar, cascading good fortune followed. The trust and goodwill of others enabled my practice to flourish. I continued to have great mentors who were generous with their time. Taking a walk down memory lane, omitting honorifics and post-nomials, these included John Clark, Bruce Murphy, Russell Cox, Brian Murray, Barry Toomey, your father, Mr. Vice President, and John Brownie, with whom I read, and the great David Jackson, who, picking up one of your words, Mr. Vice President, referred to my judgments not as comprehensive when defending them, but very, very extensive. I also benefited from observing the style and tactics of many opponents and from observing the courtroom styles of the many judges before whom I appeared. I was fortunate that many solicitors entrusted me with their clients' cases in Sydney and on circuit, particularly in Grafton, Lismore and Moreland, as well as interstate and later overseas. Several of them are here today and others are online. On taking silk in 1996, I was briefed in more complex medical negligence cases in all states in Australia and later in the UK, where I was invited to join 3 sergeants in chambers in Fleet Street in London, opposite the Royal Courts of Justice, following which I was called to Middle Temple within the Inns of Court at the Bar of England and Wales. It was a great privilege to be entrusted as an advocate for the litigants in all those cases, which provided the substratum of experience for later taking on judicial life. Then came my appointment to this court. I do not propose today to discuss the cases I've heard and decided you've heard something of them. They variously included moments of poignancy, mundanity, high drama, menacing behaviour, and occasionally spontaneous humour. This is not the occasion for examples. It is sufficient to say that there were many cases and they were absorbing. Looking back on them, controversies aside, it was satisfying to reach reasoned conclusions on each one of them, although I note again that the juries are still out on 2 of them. As to my work in this court, I want to thank the Civil Registry, the listing managers, Jane Dunn, Sue Mills, Ruby Esquivel, for keeping the pace of cases up to me to ensure that I was suitably occupied. What I also wish to say is I want to thank the whole judicial support team and the Judicial Commission staff, too many to name here, for their professional development programs and for their assistance and support over the years. Importantly, I'd also like to express my thanks and appreciation to the Chief Judge and his Associate Executive Assistant, Lisa Freeman, for managing the difficult task of keeping the show going so efficiently, despite the challenges posed during the time of the COVID pandemic. Looking back, my career achievements did not occur in a vacuum. They were grounded not only upon the mentoring I received, but also on account of the continued patient forbearance and support of my loving family, whose presence I now acknowledge. My dear wife Eva, who went on to change careers and obtain further degrees in history, political science and social work, has had a stellar 25-year career as a skilled clinical social worker. She achieved all that whilst also shouldering the lion's share of the work of raising our family, a matter I acknowledge with due embarrassment. Her dubious reward will be that she's now going to have to spend more time with me. Our three accomplished daughters, Vanessa, Monica and Philippa, and their equally accomplished husbands, David, Nathan and Brett, have given us 6 delightful grandchildren. Sophie was intending to WAG school, but someone countermanded it. After today, I look forward to spending more time with them and also returning to the court in an acting capacity when needed to continue to further serve and participate in the civil work of the court. I'm grateful for that opportunity, as I feel that I still have some fuel in the tank and I do not feel yet ready to retire completely. In addition to taking up the acting position, I also have another exciting situation on offer on the bench, unconnected with the law, but in silversmithing. On a pre-COVID visit to Copenhagen, the production manager of the George Jensen Smithy gave me an open invitation to come and practice the different techniques at the benches of their workshops, having admired Jensen designs over the years, 50 years. That is a dream come true. In closing, I have not overlooked the fact that from time to time many people have remarked to me that in allowing me the space to do my work over the years, my family deserve medals for their forbearance. Eva, our daughters and granddaughters have over the years been regularly receiving their medal equivalent trinkets on account of my hobby. In a similar vein, people have often remarked to me that my associate, Mrs. Dulce Lello, who has been with me for 42 years, first as my secretary, then PA, and now as my associate in this court, also deserves a medal for her unstinting faithful service both to me and to the court. She has also always risen to the occasion, including when the pace seemed both Herculean and frenetic. Court officer, can you please come forward? Could now please approach your mother. Mrs. Lello, could you please stand and receive this medal, which I have fashioned for you in appreciation of your diligent, distinguished, long and loyal service over the past 42 years. Thank you, Chief Judge. Thank you all for sharing this occasion with me.
Before we adjourn, I warmly invite you all to join us for morning tea. The court will now adjourn.